And Kiran is with such an experience. He has implemented GDPR and data protection across the world in Middle East and for the European customers. It's actually a pleasure to have him with us. It's a pleasure to have you all with us. Okay, all the intellectuals join us for this webinar. Okay, over to you, Kiran. Thanks, then. Kiran, you are on mute.
Yeah, thank you, Subbu. I was talking in mute and I'm sharing my computer screen. Yeah. How do this? Not pretty much used with the team, Subbu. I'm just trying to get rid of this.
Yeah, and for the people who are not speaking, can you please go on mute? Arun, I request you to go on mute, please.
All right. Thank you all for joining this webinar session. And myself, Kiran, and I have around 14 years of experience in governance, risk, and compliance. And in terms of data protection and privacy, I've been almost 2 years, and I have implemented GDPR and helped a few of Middle East customers with PDPL and learning the India DPA as well. And in this webinar, we will understand the significance of data protection laws and then overview of the India DPA, GDPR and PDPL and their key differences, and the implementation strategy and strategies for ensuring compliance. And the first thing is understanding the data protection laws and why the data protection law has came into existence because of various factors. And the first one is individual privacy rights, wherein an individual will have the rights, whether a private organization or a government organization, and can process their personal data or transfer their personal data to a different establishment or a different country, and right to erasure and certain other rights that the individual can own. And earlier there were multiple data breaches across the countries, and the European nation was the first one to establish a data protection law. Unlike ISO 27001 and GDPR or the DPDPA or PDPL doesn't require a compliance certification. However, the best practice is to go with ISO 27701, the privacy standard, where that would help in adhering to the various privacy laws. And then it also helped a lot of trust and confidence between the data subjects and how the data is being handled within the organization and how it is secured from data breaches as well. And the cross border data flows, which is nowadays most of the organization is globalized, and most of the data controller have all their data processes away from their establishment or in a different country. And so we need a data protection policy even for the processor who process the personal data of the particular individual from Europe or India or and Saudi Arabia. Unlike EU region, wherein the PDPL and the DPDPA, they do not have cross-border data flows, and much more seen as like in GDPR. And one more important factor. I'm sorry, I would request you to go on a mute and you All right. So,
Murugan,
and then
Murugan, can you please mute yourself? Kiran, you can mute Murugan actually, please.
yeah, sure.
We can mute everyone now, and QA session can be allowed at that time from admin side.
All right, I'll do that then. Sure.
Yeah.
And then there were a lot of identity thefts and misuse and abuse of the personal data as well. And uh, and there were a lot of data breaches and lack of accountability from the controller standpoint. And considering all these factors, and the data protection law has been introduced, wherein any data breaches for a particular uh, data controller, where hefty fines were charged. And so let's have a deeper look. This is an introduction why data protection law has came into existence, and we'll have a deeper look on the key differences between the multiple data protection laws. And so I have highlighted only few key differences, but I would like to speak more about the other differences between the multiple data privacy laws. And wherein the it's more common. There are many common clauses in GDPR, PDPL, and the DPDPA. But the difference in the DPDPA is wherein the data subject is called as a data principal, wherein the data controller is called as a data fiduciary. There is a change in terms of words, and then and the common changes again, changes in the fines and changes in the breach notification, wherein GDPR has 72 hours, wherein the controller have to report to the authority within 72 hours about the data breach, wherein PDPL doesn't give an explicit timeline, but it has mentioned the data breach notification needs to be immediate. And wherein it's the DPDPA also refers the same. It hasn't explicitly mentioned the time, and but the data fiduciary needs to be with an assumption of within 6 hours, or as soon as possible. It needs to be reported to the data protection board. And in terms of deceased individuals, wherein in GDPR it doesn't calls out where the deceased individuals data can be processed or not, wherein the PDPL, it explicitly calls out the deceased individual data privacy is also a concern for processing, and any of the family member can remove the consent or notify the data controller, and it applies the same the DPDPA as well. And again, when it comes to the consent manager, and this is something different that we can see in the India DPDPA, wherein the data principal, it's called as data subjects, where can contact consent manager, and they can revoke the consent or that has been provided for processing their personal data, or or they can or they can request for erasure. Any rights pertain to data subjects can go via the concern manager, wherein the concern manager can take it to the data fiduciary and have this sorted. And in the India DPDPA, they have mentioned a grievance, where the concern manager will take care of the grievances from the data principals, and have it sorted on behalf of the data principals, where he will coordinate with he or she will coordinate with the data fiduciary. And the DPDPA, India's DPDPA have designed only for the digital personal data, wherein GDPR and PDPL, it has mentioned, and the data could be any form. It could be digital or any other form. But wherein in the India DPDPA, they have explicitly mentioned that the data privacy law is applicable for only the digital personal data. And in GDPR, we can see this anomalized data, wherein this was not mentioned in the DPDPA or the PDPL. And then when it comes to records of processing activities for processor, and wherein we have this in the GDPR and absence in the PDPL and the DPDPA as well. Even in the PDPL or the DPDPA, they haven't mentioned the records keeping or the format for records of processing activities. And rest of the clauses are almost similar. All the three data privacy frameworks have in common in terms of rights to rights of data subjects for erasure or cross-border communication, and appointing an DPO. The roles and responsibilities are also same for all the three data protection laws. And these are the common differences that I have seen with the multiple data protection frameworks. And I will unmute here, and so if you have any questions, so that we can discuss and talk about this key differences.
We are fine, Kiran. Thanks.
All right. So, and then I will quickly move on to the scope of data protection. And I have, when I have been with multiple customers, always there is a question: what would be the scope of data protection, whether the data protection is applicable for us? And it could be GDPR or the DPDPA or the PDPL. And I have made a simple chart for a better understanding. And if any organization is processing the personal data, and they are within the EU region or Kingdom of Saudi Arabia or in India, yes, they are applicable, and they have to follow the data protection laws. And offering goods and services to data subjects in European region or Kingdom of Saudi Arabia or India, again, they are applicable with the respective data protection laws. And here, one more point is monitoring behavioral of data taking place. This clause is only available in GDPR, wherein Kingdom of Saudi Arabia or the India DPDPA doesn't explicitly speak about the monitoring behavioral data as well. So on all these conditions applies for the respective public or the government sectors or non-public sectors to have the data protection laws implemented. And if they doesn't fall in any of these factors, and it doesn't apply to the data controller. And the next one is the implementation part. And unlike other frameworks and regulatory requirements or standards, we usually start with the gap assessment and to understand the current state of the organization, irrespective of any data protection laws. And once the gap assessment is performed, and then we will have the idea of what needs to be implemented, what is already exists, and that can be reviewed and modified as per the data protection laws. And once the gap assessment is performed, and we will present it to the board and of an organization. We'll explain them the identified gaps and the potential risk, and then essentially we will also create a framework and data protection policies. And this framework will be tailored from either, for example, if it's a EU-based organization, we'll tailor the framework based on GDPR. And similarly, it goes with the PDPL and the DPDPA. We tailor and then we create a framework, and then data protection policies. Data protection policies, and there are two types of policies that we usually create. One is for the customer, that you can usually see in many of the customers' websites, and where it contains the cookie consent and data subject consent and revocation process as well. And the other the data protection policies that we create is for our internal employees, and because that is more specific to the HR department, the personal data collected for the internal employees. And then we also go with the data maps and records of processing activities as well. The personal data flow within the organization from the time of user provides the consent and storage of the personal data and the security controls, and all this will be documented and mapped. And then we also perform the record and processing activities, what kind of data is being processed within the organization. And it is usually we document it, and after documenting this, then we would go and do the data privacy impact assessment, and any risk identified during the data privacy impact assessment, and that will be again discussed with the leadership team, and then we try to mitigate the risk associated with the data privacy. And along with this, we'll also maintain a data asset register, and with the third party vendor risk assessment we also perform in terms of data privacies as well. And then it goes with the procedure and forms, and to conduct an ROPA, what would be the procedure that needs to be followed. And for DPIA, again we will draft the procedure. And forms, again it goes with the user consent forms, and then user consent revocation form, cookies consent form, and there are other forms that is needed for procedure that is needed for data privacy will be documented as well. And here when it comes to contracts for processes, there are specific clauses that we will mention as part of the vendor contracts or the processor contract. And also we request a particular processor um, to sign up the data protection policies. And again we will also provide some we will also assess the processors, and on a periodic basis whether the required controls are being processed or not. This will be carried out as part of the third party risk assessment as well, wherein GDPR or PDPL or the DPDPA doesn't gives us a method, this is how you have to implement, but it is our responsibility to maintain the compliance. So we follow additional mechanisms that applies for even for information security. So we also include the third party risk assessment to ensure uh, the data protection and to avoid data breaches as well. And this training and awareness program is not only conducted for the internal employees. We will also consider vendors and our processors, and as part of this training and awareness program. And this would be conducted on an annual basis. And then when it comes to maintain the records, and ROPA, DPIA, and all these records will be maintained, and whenever it's needed, and we will present it to the authority, or if the organization undergoes an external audit, we'll present it to them. And so here, and the steps are similar for implementation, but most of them will have a questions: what kind of policies, procedures that I should have within my organization, and what kind of procedures or forms that is more clear and explicit, so that we can have that implemented. And what to make it easier, I have put that as a documentation and records which is required for implementing all the three frameworks, the data privacy regulation requirements. And the first one is the data protection policy, and where you mention all the clauses that is applicable as per the data protection laws. And then, as I mentioned earlier, we also uh, tailor and create the framework from the data protection laws. Either it could be GDPR, the DPDPA, or the PDPL. And then we discussed about the gap assessment and the audit reports as well. And it is also to get, unlike same as like ISO 27001, it is also better to get the leadership commitment, and always have the leadership commitment communicated to all the internal employees and the vendors in terms of protecting the personal data. And again, the third party register, what are the data that is being processed by the processor. It is always a best practice to maintain a register. And then it's the usual, the data consent form and the privacy notice that you can see it in the website, and cookies policies. And it is also the best practice to keep the data breach notification response procedure, and a letter uh, in terms of, in case of any data breaches, how do you respond to the supervisor authority, what information that needs to be available in terms of the breach notification process, and applies same to the data subject as well. We usually create a standard template, and in terms of the notification process to supervisor authority or data subjects. And and then again, the data breach register as well. And when it comes to data breach, it's not just the personal data breach, and it could be a security incident. For example, I would say um, a particular virtual machine is breached, and you may notice a privilege escalation, some authorized access to the particular virtual machine. In that virtual machine, you may have the customer database and stored. In those case of security incidents also, we may assess the privacy data breach, and we will also record those breach, and we'll also discuss with the management, and whether that needs to be reported to the supervisor authority or to the data subjects. And then it's common, and we have the job contract of the DPO and the data privacy manager, and their roles and responsibilities are clearly defined. And I had a same question when I was performing a DL role. I was working as an information security officer, and I have given a chance to work on the data protection officer responsibilities as well. And always there is a saying that there would be a conflict of interest between these two roles, but we did not have a choice at this point in time, because the organization was very small with 80 employees in existence. So, as in this case, whether the information security officer can take the dual responsibility of a DPO as well, but with separate roles and responsibilities, and a contract letter sent to the person performs the dual role. And then same as like ISO 27001, we can also have a statement of applicability and scope document, and the interested parties, as in terms of the uh, uh, as in terms of the data privacy as well, and then subcontractual clauses, information asset register, and other common documents that can be put in place, and wherein there might be few challenges that you may come across during the implementation process. And as I have seen that most of the organization may use the and they use the um, um, I'm sorry, please give me a moment. All right, so most of the challenges is, and most of the organization may not have a proper records, and some may implement um, the user consent form in their website, and after the user provides the consent, and they doesn't have a track where the personal data is stored and how it is secured or not. So these are the this is the primary gap that we found in most of the organization, and then in terms of cookies consent as well, both were identified primarily. And then most of the organizations, and they do not have a KPI, and so for data privacies as well. And when it comes to KPI, records of processing activities, or the DPIA, it needs to be done on a quarterly basis. A periodic review needs to be done. And even the data protection policy needs to be reviewed annually with the top management. And then the necessary changes are made if required. And so that's sort of it with the implementation process and the difference between the GDPR, PDPL, and the India DPDPA. And let please let me know if you have any questions. I'm happy to
Yeah.
answer.
Hi, Kiran. This is Bhaktadas. Very informative session. Thank you so much for sharing the information. Now, looking at the implementation process, my question is twofold. First question is, typically, how long does it take to implement whether GDPR or PDPL in the organization? That's number one. Number two question is, once this is implemented, probably most of the work is done, right? What does the DPO do on a day-to-day basis once this is implemented and in operation?
All right. So to answer your first question, Dr. Ras, and it depends from organization to organization. An organization with multiple entities, and it would hardly take 6 months to 1 year, wherein a small organization with a limited, um, for example, with the limited entities, and it would possibly take 3 months for implementation. I can give you an example, and the recent organization that I have implemented GDPR, wherein we had our um, presence only in Europe, and we did not have a processor as well. We are the only controller for the for processing the personal information. So as in this case, it took only 3 months. And so to be more precise, it depends the organization process type, and how big the organization. The timeline takes from 3 months to 1 year to implement. And
Okay.
to answer your second question, after the implementation, what would be the responsibility of DPO? DPO is it's periodic reviews of all these processes, and and all this would have been mentioned as part of the DPO contract, and wherein the DPO has to perform the records on review and has to review the records of processing activities, and periodically he has to perform the data protection impact assessment, and he also has to review all the policies, procedures, providing trainings. And so I can give you a specific example. Let's say I'm building a new application for a retail organization. An organization is not going to stop building new applications, or always an organization is they tend to increase the revenue or increase the profit. They build more application and they need more customers, and in that point in time at that point in time, an organization may develop a new product, and they may develop a new application. For every new product and application where the user where the customer visits the website, or the customer personal details are collected during the purchase of the product, at that point in time the DPO has to update the ROPA, and then he has to perform the DPIA for the personal information that has been collected. So it's not just an implementation. Again, the more responsibility relies with the DPO is to perform a periodic review. I hope that answers your question, Bhaktadas.
Yeah, it does. Thank you so much.
So, yeah, hi
You are,
Kiran.
thank you.
Hi Kiran, with
Hi,
your
Manoj.
permission, I just would like to add a few more things to the first question.
Sure.
So, yeah, Bhaktas, the first point you said, that's really very tricky, that how long, it takes going to take for implementation part of it. So with my experience, I would just, like to add that suppose organization is already ISO 27001 certified, PCI DSS certified. I mean, already there is a, base is already there. So in that case, it takes less time because people are aware, everybody is aware what needs to be done. And the main focus is only on that, the personal data that is all about GDPR, DPDP, whatever we are talking about. So in that case, takes less time. But if we have to start from the scratch, then, I mean, we had multiple discussion with Subbu in other forums. So ISO 27000 form, one forms the basis part of it. So it is again, that is another factor that, impact the implementation time. Yep. Yeah, that's it. Thanks, Kiran.
Okay, thank you.
Yeah, you're welcome.
Yeah, hi Kiran. This is Chetan Patil here. As an example, I will give you one example. Like there is a there are systems. There is a project, or there was a project where I was working on with a customer, and there are systems where the OS or the databases that are outdated. These are the unsupported versions, and I think they also store some of those databases. They do store the customer identifiable data, and those are pretty old systems, so nobody's rather those patches are not available, and even the security officer in that organization has accepted a risk. Like every year it's like, oh, okay, this is a risk, do you accept, okay, then everyone moves on. So in such scenario, what is DPO's responsibility? As a DPO, if I know that there is a lapse in security, should I be raising it with the that particular authority in that country, or should I raise it with senior management, or should I just shut up and keep quiet and wait for that incident to occur? So how this situation should be handled?
It is a tricky question, Chetan. So yeah, I agree. So they have a outdated system and patches are not available. Every year they accept the risk, and the senior management is also aware of the potential risk that may cause a data
Yeah,
breach to the
yeah,
data subject as well.
yeah.
So typically, I would say the answer is a little complicated, but I would say when I look from data subject standpoint, and thinking of the data privacy and its I would suggest that the management to reiterate or convince the management about the data privacy, because the data privacy law says if the particular organization is not following, we can directly report it to the supervisor authority if you do not get enough support. And as performing a DPO role,
Uh,
you cannot go and take your own organization to the supervisor authority telling that these practices are not followed, right?
yeah,
And
exactly.
rather that and the DPO role itself, and that's the reason it's very difficult to perform a DPO role. So, and same as like CISO, you
Okay.
might have some technical controls that might not apply. It is always better to go with good pointers and convince the leadership team and explain them about the potential breaches and hefty fines. And so that's the best practice, or that's the
Okay.
best way that we have to perform. Yeah,
Good. Thanks.
No, no. Just to add on to
that's
this.
from my.
Yeah.
Yeah,
So Kiran, just to add on to what your answer is.
sure.
See, the privacy doesn't exist in a silo. Okay, it is,
Hmm.
as I really mentioned in the class. So we have a security team to support, IT team to support, legal team to support, and the assessment team also to support. Now, the it comes under the enterprise risk management and security risk and then privacy risk. If the DPO is going to find a gap somewhere, okay, he will immediately flag it as a risk. Now, it depends upon who needs to fix it. Okay, now if he's not
Hmm.
going to raise it as a risk, okay, then if there is going to be an incident, then he is also to blame, right? So because security is everybody's responsibility, and same privacy is also everybody's responsibility. It's always better to flag it as a risk, and it is there, okay, and somebody is taking the ownership of it to actually fix it. If that process is not being followed, then everybody has to get blamed for it, Chetan. So
Yeah,
we,
but then
yeah,
after
yeah,
raising the
Chetan,
risk,
please.
say that, oh, okay, we know the risk. Okay, let's move on. Because
No, then
so in
accept it. And who's accepting it? They have to sign the what we call a dispensation form, right? Or it's going
Acceptance
to be like
form.
uh,
an
Yeah.
exception form. So they
okay,
want the risk. Okay? And if they're going to
okay,
be an audit, and the auditor is going to say it's a non-conformity, they need to answer the auditor. That is number one. And if it's going to
ah,
be an incident, okay, you cannot blame the DPO. Okay, he has done his
ah,
job.
ah,
He's
ah,
not going to fix the gap anyway, and it's a
hmm,
security or IT team to fix it. Then they have to
got it.
take the accountability of facing the consequences.
Okay, okay, thanks. Thank you.
Thanks, Kiran. Over to you. Thanks, Chetan.
Yep. Any
Kiran,
other
over to you.
questions? That's sort of it, Subbu, from my side. And
Yes, so okay, thanks, Kiran. So, Subbu, there is something, I was reading that is on related to European Union Cyber Resiliency Act. I don't have much, information on that. I was told that by this year, April or May, it may go live and it goes along with GDPR. So there's something you can give us thought on that.
I can, because I'll tell you why it's happening. Because UK went ahead with, Chetan, correct me if I'm wrong, as an online security act or something. They went forward with it by late 2023. Online security act or something.
Yeah, something similar. Yeah.
Yeah, so I think that they're covering close to around 15 points in that particular act. I would like to give a webinar on that also, but when I'm doing it, I will also consider this European Cyber Resilience Act, and we might club together to do it.
Yeah.
Because I know where it has cropped from. Because GDPR had become the complete European takeaway when UK was a part of the European Union. Now it's a Brexit, then we have UK GDPR, EU GDPR. But when UK came with a new law, okay, for securing the people online, it's a law now in UK. I think the Europeans are also following it. I'll compare that and we'll do a program on that as well, Manoj. Thanks.
Okay, thanks.
In fact, I would bring it like a school. Okay, you ask me a question, then you have to actually answer it. I wanted to request you, can you please deliver a webinar for us on the European cyber resilience? Okay, then I thought it will be too
Let's
bad for
work
me.
out. Yeah, sure. Why not? Let's work out.
Yeah, you'll do that.
Yeah.
Yeah, okay. Kiran, anything else from you, Kiran? Are we done?
We are done, Subbu, from my end.
Yeah. So, any questions from anybody here on the forum?
Subbu
Senthil,
Sendil
you have a
here.
question.
Subbu Sendil here. See, for example, if we have a company, so there is a startup company, and they are going to implement an GDP, right, data protection.
Yeah.
So, for example, see my assumptions. They initially the HR person, all right,
Yeah.
who will be collecting the data from the new joiners, right? For example, name, date of birth, and I'm just thinking, I'm just mapping has there we are having collecting in India, for example,
Yeah.
PAN card and Aadhaar card, all right.
Yes.
So normally, so HR person is I'm sorry, the person from HR is responsible of collecting the data, where they will be implementing the data protection thing, right? So from there, so whom should they need to get an approval from the governance? But that means from government or um,
No. Okay.
any body.
This. What? You're speaking about an organization, right?
Yes, organization. Because
Yeah.
as a Sendil, if I give my PAN, or if I give my Aadhaar number, right? Aadhaar number, where they will be nowadays, it becomes Aadhaar is one of the key field. So the if anybody is trying to hack my data for Aadhaar, so they'll be having try to get my bank details and family details and all, right? So in that case, so from whom should we need to get an approval from the government body?
For no, no.
Mm.
Okay, we don't need to, for collecting the PAN card. You're saying?
Uh, no, no, but data, collecting the PAN card details, not a PAN card and Aadhaar numbers. Uh-huh.
Okay. See, that's why on the data protection we have something called as a the first principle is lawful.
Mm-hmm.
Okay, so you need to have a lawful basis for collecting it. You are collecting the PAN card for what purpose? Because you have to submit the income tax details
And,
to the government or income tax department at end of the year. So you have a lawful
mm-hmm.
basis to actually collect it. So you don't need to get a permission for collecting it, but you need you need a consent not for the PAN card, because if the employee is going to say that no, don't share my PAN card to the income tax department, you cannot do it. No, you have to share it because it's a
Yeah.
national law. Okay, so you have to abide by it. No, the consent is only when you are collecting the personal data. That is first name, last name, email, mobile number, and the house address. Because you need to anyway do a verification, right? So what you will actually do,
Mm-hmm.
for example, if I am joining your organization, so how will you trust me? You will give my data to a third party. Okay, third party organization will do background verification. Check my mobile number, check my residential address, and check my email. Mobile number and email can be done online, but residential address you need to come physically and you go to the local police station, do all the checks. This is something that you'll get the consent. If they don't give the consent, then they're
Mm-hmm.
you cannot take them on board. Okay, this becomes your policy. So the employees have to say yes, because it's you have
Okay.
all the rights to do the background verification, because we cannot recruit a criminal, okay, to the
Mm-hmm.
organization. You cannot take him on board. Now that part is actually done. The consent could be a part of the offer letter also. You don't need to have a separate consent.
Mm-hmm.
Okay, so
Okay.
that is number one. Because after I come on board to your organization, you might also share my details with your customer who want to evaluate me and take me on board. Okay, for on-site visit, blah blah blah. All these things will be there. Now, the HR will not. It doesn't require an approval from the government body. No, it requires a compliance with the law. In case, okay, for example, I'm buying a company lease car, because it happened to me. I bought a company lease car when I was a part of a very big organization. When the car's insurance was about to expire by the end of the first year, I received a quotation from multiple insurance company. Now, how do they all know my details? Because the company actually shared them. Okay, but this
Mm-hmm.
happened 12 years back. Okay, that time nobody, even GDPR was not there. It was introduced in 2018, right? But now, if this is going to happen, it raises a concern for everybody. How do they actually know? This is something that we also had in our Elite CDPO WhatsApp group. Okay, so we had a discussion about this people, their information is getting leaked out. But till date, DPTPA is not a law in India. And after the election, we are expecting it to be a law. And after that, things will obviously change. Okay, to collect the information, it requires a consent as a part of the offer letter. They might or might not have a separate consent, but if they are part of the offer letter also, it's actually okay. You need to follow a law. The government regulatory body will not step into your shoes unless otherwise there is going to be a privacy breach. Privacy breach is inherited by the security breach. If the security breach leads to an incident where the personal data is exposed, we call that as a privacy breach.
Okay. All right, Subbu. Thank you. Thank you. Just trying to
Yeah, Subbu, one thing, I mean, as we know that, GDPR, once I have implemented, I can declare it is kind of self-declaration that, yes, I am GDPR compliance. I was talking to one of the consultant, for my organization, and they said, yes, it is self-declaration, but audit part of it, to prove that the organization has undergone rigorous audit and things are in place. I mean, we have to showcase that we have got it done, audit got it done from some external vendor. Is that required?
Not necessarily, actually, but I'll tell you something. See, the concept is like this: if a doctor is going to do a health check on himself, he's always fit. If the astrologer is going to look at his horoscope, he's going to live for 120 years, right? He will overlook certain things. To avoid that, you need to go for a third party, but it's not a mandate.
Okay.
So the third party for your comfortability, because out of the box thinking, right? The third party will always try to find something, a gap in your implementation. Only for this, for that we are actually going to them. But if you are in GDPR, they don't ask, did you have an external auditor doing it? You can show an internal audit report. That's absolutely fine.
Okay.
There are times where the non-conformity has been brought to the notice when the internal audit has been done, but the external auditor would have missed it because external auditor works on what is called as a sampling. See, every day we are paying him, right? For example, if you're going to pay him $200 every day, okay, and then he's going to give a quotation for 10 days, $2,000. What the company will say, sir, don't come for 10 days. Try to complete it in 5 days. So what he's supposed to do in 10 days, he will cover it up in 5 days because the company wants to save the money. Okay, now in the 5 days he will be doing only a sampling. There are a lot of chances that he would have missed a non-conformity, which is practical, which is fair enough. Okay, but the internal auditors are not like that. It's done by the organization, right? So the internal auditors work for a salary. So the company has to get them engaged anyway on the work, so they can do it, and they can also do the audit, and they can give an internal audit report. That is also fine. So, because an external body is doing an audit, that doesn't mean that they are perfect. And because we are doing it internally, that doesn't mean that we are imperfect. So, if we are going to do the audit wholeheartedly, it is more than enough. See, finally, the supervisory authority will pitch in. Okay, only when there is going to be a privacy breach, privacy incident. Okay, now if the internal audit is strong enough and all the controls are strong enough, we are not going to face the privacy breach at all. So, there's no way that supervisory authority has to come to us.
Yeah, thanks.
Thanks, Manoj. Are you all okay? Any questions from anybody here in the forum? Great then. So thank you very much, Kiran. I will get this thing recorded, and then I will share the link for recording.